If the state has failed to prove any one of the elements, the defendant is not guilty. Instruction number 29. You may not communicate about this case before reaching your verdict. This includes cell phones and electronic media such as text messages, Facebook, MySpace, LinkedIn, YouTube, Twitter, email, etc. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case, and do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case will be tried on evidence presented in the courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth, and by cross-examination. All of the parties are entitled to a fair trial, rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It's very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried. It's important that we have your full and undivided attention during this trial. Instruction number 30. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them, and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room, and they will be destroyed. Instruction number 31. When you begin your deliberations, you should select a presiding juror. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong, but do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors or for the mere purpose of returning a verdict. Remember, you are judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 32. Occasionally, after a jury retires to the jury room, the members have questions. Usually questions about instructions can be answered by carefully rereading them. If, however, any of you feel it necessary to ask a question, you must do so in writing and deliver the question to the court attendant. I cannot communicate with you without first discussing your question and potential answer with the parties and lawyers. This process naturally takes considerable time before I can reply. Please keep the written question and the court's response and return them to the court with the verdict. Instruction number 33. Smoking is prohibited in the jury room during deliberations. If a juror feels it necessary to smoke, the juror must leave the jury room and smoke in an area designated by the court attendant. During this juror's absence, the jury may not continue to deliberate, as all jurors must be present during deliberations. Instruction number 34. I am giving you 2 verdict forms, one for each of the counts in the trial information. Each verdict form has several alternatives. You will use one alternative on each form. When you have agreed upon verdicts and the presiding juror has signed the verdict forms, please notify the court attendant. That concludes the reading of the legal instructions that apply in this case. Members of the jury, it's now the time and place for counsel for each side to present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply. And since he will only address you once, he will also present his summation. Counsel for the state will then have her closing summation to the argument of the defendant. The counsel for each party will be summarizing the testimony that you have heard and the evidence which was presented during the trial. They will merely be recalling the evidence, as you will later. They will not intentionally try to mislead you, and if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are merely that, summations. They are not evidence, nor should they be construed by you as evidence or as instructions on the law. The court has just given you the legal instructions that apply in this case. The summations are intended to help you in understanding the contentions of each side, so please give them your close attention.